My lords, my lady, my learned friend Mr. Lewis has kindly indicated that I should make the application that has arisen overnight to amend our grounds of appeal, ground 2, following the discussion we had yesterday. I've reflected on whether it's achievable to make the submission under under the ambit of Section 71. And the conclusion I have reached following a review of particularly the authority in Ashtabula, is that that's not achievable, and so my application has to be to amend. We have provided an amended grounds with the words in ground 2 added, and therefore not unfair within Section 62, and provided a draft order. And the basis upon which we make the application is as follows. It's set out in short form in the application. Point 1, Mr. Justice Bright would not have stayed the order, the enforcement order, if he had not intended for all of the issues to be properly canvassed by this court. That seems to be a logical conclusion from his order. He wasn't creating an appeal on the grounds of academic interest only. Secondly, if there is a fault here, a technical fault, the lawyers have to accept responsibility. It can't really be laid at the door of Mrs. Zhang. And thirdly, the scope of our application in relation to ground 2 is limited to transparency now, and consequently the arguments that are canvassed before the court both anticipated substantive unfairness under Section 62 and covered them, and so it's for those reasons.
So is it your new amended case that the clause is unfair because it is not transparent?
Yes.
Rather than for any wider reasons that there might be.
The case is the case in relation to clause 2 has been primarily advanced on the basis of a lack of transparency, and that is the sole reason that we ask the court to consider it to be unfair. And so for those reasons, the scope of the amendment does not materially alter the shape of the case.
Yes, all right. Well, thank you very much. Mr. Lewis, subject to anything you want to say, I think we're minded to hear the arguments de bene esse. If you want to make submissions that we ought not to permit the amendment, then you can do that in the course of what you have to say, and we'll consider that and deal with it in the judgment.
I'm grateful. There are 4 reasons why, when giving that judgment, we say that the amendment should be refused. 1, it's very late. We received it at 10:40 last night. My learned friend and I have both made our submissions on ground 2 already. 2, there's no excuse for the lateness. The point was taken that the appeal was insufficient as a challenge to the judge's order in paragraph 5 of our skeleton dated 12th October last year. Point 3, it has no real prospect of success. As I showed your lordships yesterday, a transparency finding is an insufficient basis for an unfairness finding. The tests are different. As a matter of logic, a core term might lack transparency, but when properly understood, be tilted in a consumer's favour, or alternatively, be well balanced, and so not significantly imbalanced under Section 62. Point 4, it sets a bad precedent for other court users if a party can ignore a respondent skeleton and then try and amend after oral argument. 3 follow-ups on points that arose yesterday. 1, place of payment of the sums due under the PG on demand. We have in the supplementary bundle a copy of the demand. It is tab 6, page 73. And at page 74, the demand is for payment to Hang Seng Bank, a Hong Kong bank. Second follow-up.
I mean, that's an after the event point, which, if you're right on your other submissions, wouldn't have very much weight. Although, what you can say, I suppose, is that looking at the situation as it was at the time of the guarantee, it was always to be contemplated that a demand was likely to be for payment to a Hong Kong bank.
Yes, it may shed light on what was predictable at the time of the guarantee.
I mean, there's no evidence, is there, that you had bank accounts in London?
No. Follow-up 2, as to the schedule of absences and its origin, that is referred to in the award, supplemental tab 8, page 149, paragraph 136. There is the point I mentioned about Mrs. Zhang correcting her mistake as to where she was when she signed, and the tribunal then quote a passage from her written evidence which says, "I have since then been shown a document." Footnote 112 explains that document. It is the schedule of absences submitted as part of Mrs. Zhang's application for naturalisation as a British citizen. That explains its date in December and shows it to have been a document that originated with her, or at least from her side.
Thank you.
Third and final follow-up point as to the BVI proceedings. They are mentioned in Mrs. Zhang's second witness statement, supplemental bundle tab 12, page 201, paragraph 2.10, when putting in some evidence as to assets, Mrs. Zhang talked about the legal fees she was incurring and referred to a number of sets of proceedings in which she was engaged, including at subparagraph 2, the Eternity Sky enforcement proceedings in BVI in relation to the award. The fourth reason why we say the appeal should be dismissed, and this is part of the court hearing about substantive unfairness on a de bene esse basis, is that the judge was correct to hold clause 2 was not unfair under section 62 CRA. And that is A, because it does not provide a significant imbalance, and B, it's not contrary to the requirement of good faith. The legal test is set out broadly in the key dicta from Director General of Fair Trading and First National Bank at paragraph 143 of the bundle. I then just want these to show one CJEU authority. It is BNP Paribas against VE, which is Authorities tab 2, volume 2, tab 50, page 1225 or 1202 in the E bundle. It's been relied upon by Mrs. Zhang on transparency, which was the third and fourth question answered by the CJEU here, consistent with what I've just said about different tests. I want to show you how the court dealt with substantive unfairness on the second question on which a preliminary ruling was sought. That starts, please, at page 1239, above paragraph 58. And if one turns on to paragraph 61, one sees there are 3 separate requirements, all wrapped up in the substantive unfairness test: good faith, balance, and transparency. Paragraph 62 then says, thus the transparent nature of a contractual term is one of the elements to be taken into account in the assessment of whether that term is unfair. The court then goes on to explain how the other 2 work, and at paragraph 64, it is for the National Court to consider good faith and significant imbalance. Paragraph 65 covers good faith. Analysis is required of the strength of the parties' bargaining positions. This is similar to Lord Bingham saying how the fair dealing requirement is that a supplier should not take advantage of a consumer's necessity, indigence, lack of experience, unfamiliarity, or weak bargaining position. Paragraph 66 covers significant imbalance and the counterfactual question: could the trader reasonably assume the consumer would have agreed the term in individual contract negotiations? Finally, paragraph 69 shows that the significant imbalance test involves an assessment of the proportionality of the risk taken to the services provided. So, applying the substantive unfairness test to the facts, firstly, Clause 2 does not provide a significant imbalance in the parties' rights and obligations. Paragraph 156 of the judgment contains a relevant and correct finding which led to the conclusion at 164, namely, Mrs. Zhang would not have been surprised by Clause 2 had she read it. To apply paragraph 66 from BNP Paribas, Eternity Sky, dealing fairly and equitably with Mrs. Zhang, could reasonably assume she would have agreed to such a term in individual negotiations. It was a standard guarantee term. It was proportionate to the consideration, namely the 500 million Hong Kong dollar advance. There was nothing disproportionate in Mrs. Zhang, as one of the majority shareholder couple in Chongqing, guaranteeing the convertible bond repayments plus interest in exchange for that advance. Clause 2 was a reasonable price to pay for the company in which she was one of the majority shareholder couple receiving that advance. The clause indirectly favoured Mrs. Zhang in the sense that it made the $500 million available to that company, which might not otherwise have been available to that company. To apply the words of Lord Bingham, the clause is not so weighted in Eternity Sky's favour as to tilt the parties' rights and obligations significantly in Eternity Sky's favour. My reason 4b, clause 2, is not contrary to the requirement of good faith. Applying paragraph 65 of BNP Paribas. There is no basis to say that Mrs. Zhang was in a weaker bargaining position than Eternity Sky. To apply the words of Lord Bingham, Clause 2 does not involve Eternity Sky having taken advantage of any necessity, indigence, lack of experience, unfamiliarity, or weak bargaining position on her part. Unless there are any questions, I propose now to hand over to Ms. Morgan to deal with the consumer issue.
Yes, very well. Good. Yes, certainly. Just where your microphone needs to be moved over to. That's what's happening now.
Thank you very much.
Yes.
My lords, my lady, I will address you on Eternity Sky's cross-appeal of the judge's finding that Mrs. Zhang is a consumer within the meaning of Section 2.3 of the Consumer Rights Act, and therefore that the terms of the guarantee fall to be assessed under that Act. Eternity Sky's case is that Mrs. Zhang was not a consumer, in summary for the following 3 reasons. 1, an individual guarantor does not act as a consumer if they provide a guarantee because of a functional link, such as a non-negligible shareholding, with the company whose contractual performance they are guaranteeing. That is the test given by the CJEU in the 2015 case of Tarkow, and is understood to be common ground. 2, in this case, Mrs. Zhang did have a functional link with Chongqing because she had a non-negligible shareholding in it, and the judge was wrong, we say, to find that she did not. Specifically, just giving the headline at this point, she had a familial shareholding interest, together with her husband, of about 18%. And because of that...
So 1/8.
18. Yes, 1/8.
1/8,
yes.
yeah.
Because of that familial interest, she was treated publicly, and in the context of the subscription agreement and the personal guarantee, as being one half of Chongqing's majority shareholding couple, and considered or deemed to be a substantial shareholder in her own right. Further, she had a personal shareholding of 0.39%, which was worth, at the relevant time in May 2016, around £5 million. And we say that the actual value of that shareholding is material to the assessment of non-negligible, and the focus should not be, the judge found it to be, on the percentage shareholding alone. And our third reason, then, is that in providing the personal guarantee, Mrs. Zhang did so because of that shareholding. We say that the objective evidence shows that Mrs. Zhang provided the guarantee because she was one half of the majority shareholding couple in Chongqing. That was the reason why the personal guarantee was sought from her specifically, as opposed to from any other wealthy person who was willing to assist. The shareholding was, in the language of causation, the effective cause of the guarantee coming into being.
Well, one aspect of that, which perhaps you could consider when you get to develop that, is that her evidence was that she was signing all sorts of documents for her husband. Personal guarantees, anything he asked her to sign, and that she didn't necessarily know what they were or trouble to find out. She was simply happy to sign them, and that seems not to depend on whether she had a shareholding in the particular company which her husband was dealing with. I mean, it wasn't simply Chongqing, it was a whole range of companies as far as her evidence goes. That might suggest that whether she had a shareholding in the particular company was neither here nor there. As far as she was concerned, she was simply doing what her husband asked for. But that might raise the question whether these were inherently business rather than non-business or domestic transactions. That relates to the question of what is functional link really driving at, which is a point which we raised yesterday, which no doubt you're going to come on and explain to us.
My lord, I will, and I am going to develop the submission, but if I can just give you the headline as to what we say on that. I think the key words there for your lordship were, as far as she was concerned. And what we say, and I'll come on and look at this in the case law, is that the appropriate way of analysing the transaction is to look at the transaction overall. And come on and develop why we say the judge was wrong to focus on matters simply through the lens of how Mrs. Zhang approached signing things. I entirely accept that that is the evidence that she signed all manner of things. But when we come on and look at this specific transaction, through the objective lens, from the outside of what was being done, we do say that the reason it was entered into, the reason it was sought, let me put it that way, was because she was one of the majority shareholding couple. And she was aware at the time, and I'll show you the evidence, she was told the reason this guarantee was being sought was because it was needed from the majority shareholding couple. So I think it really goes, my lord, to through which lens do you look at it? Are you looking at it from the end of the telescope and Mrs. Zhang, or are you stepping back and then taking an objective approach? And that's the approach that we say that you should take. Just rounding off then on point 3, we do say that the internal subjective motives of the putative consumer are not relevant to the assessment. And the judge erred in making those motives, as he's found them, the touchstone for his inquiry, and finding, and his finding, that the guarantee contract was not entered into because of her shareholding.
The test is purpose, or purposes, which in other contexts tends to be interpreted as involving a subjective element. You say there is no subjective element?
We do, my lady, yes. And I'll come on and make that good by looking at the case law in relation to consumer. We do say that. If it pleases the court, I propose to deal with matters in the following order. First, briefly to look at the key elements of the judge's reasoning and highlight what we say are the errors so that you have those in mind when I make my submissions. And second, to consider the test for consumer. As part of that, as I've said, looking at the relevant case law, which we do say shows that it is an objective inquiry and not, as we say the judge wrongly fell into, a subjective assessment of the individual's motives. And as part of that, I also want to deal with the CMA's suggestion that the test under the CRA is broader and somehow more omnivorous than that under the directive which the Act gives effect to. And then third and finally, I'll come on to consider the application of the test to the facts, in this case to show, one, that there was a non-negligible shareholding, and two, the reason the guarantee was entered into. Dealing first then with the judge's findings, if I can ask the court please to go to the judgment at tab 5 of the core bundle, page 89. And at paragraph 73 and onwards, the judge starts with the legal principles and then goes into his analysis. And at paragraph 75, he sets out the common ground between the parties, that the relevant test for consumer in the guarantee context is that test set out in Tarkow. Now, it might be helpful if I just deal with the court's queries from yesterday, when we're looking at Tarkow, about why there was no Advocate General's opinion. There is no Advocate General's opinion, but it may be of interest to the court to understand why not. If one goes to tab 34 of the authorities bundle, we have there the Curio report of the case, and the answer to why there's no Advocate General's opinion is contained within it. So about 2/3 of the way down, past the second hole punch, if you have one, is that under the name of the Advocate General and the Registrar, it says having regard to the written procedure. So this was a case that was determined in writing, and as I understand it, there's only an Advocate General's opinion where there is an oral hearing, and that's Article 82 of the CJEU Rules of Procedure. And then if one goes over the page, we can see why, potentially see why there was only a written procedure. Under the dashes to show who gave submissions, it says having regard to the decision taken after hearing the Advocate General to rule by reasoned order in accordance with Article 99 of the Rules of Procedure of the Court. Now, Article 99, I don't have it in the bundle, but Article 99 of the Rules of Procedure provides that where a question referred to the court is either identical to a question on which the court has already ruled, clearly deducible from existing case law, or admits no reasonable doubt, the court can rule by reasoned order, effectively having checked with the Advocate General that that's an appropriate approach. So we don't know exactly which of the three the court in this case thought this fell under, but they obviously thought it was not one that would benefit from an extended analysis.
So when it says after hearing the Advocate General, that is likely to be about whether it was appropriate to adopt this procedure.
It is, and there's a reference to that in Article 99.
Right.
So that's why there's no Advocate General's opinion. And just in respect of the court's question as well, yesterday, in respect of functional links, I did some research overnight to see if I could shed any light on this question of it sort of springing fully formed in this judgment. And I'm afraid that I can't in the consumer context. What I can tell the court is that it is a phrase that is used frequently in different aspects of European jurisprudence in a number of different subject areas. And from the context in which it is used, it seems to be used in the sense of, we may simply say link, but non-arbitrary connection may be another appropriate way of using the phrase. I don't have any, there were a lot of authorities in which the phrase was used, none of which were particularly on point, but it is used with some regularity, and no specific meaning is given.
Right.
So that is the provenance of Tarkow. Then going back to the judgment, paragraphs 78, the judge starts his analysis. If I could ask the court please to read paragraphs 78 to 80. The judge's essential conclusion was that Mrs. Zhang signed the guarantee because she loved her husband, and therefore he said that the guarantee must be of a private nature. Now, we don't quibble with the judge's finding, of course, that Mrs. Zhang loved her husband, but we do say that the judge was wrong to have used Mrs. Zhang's subjective motivations, her personal emotions, if one might call it that, when signing the guarantee as the touchstone determining the question of purpose under the Act. As I've said, it is an objective test. Then at paragraphs 81 to 84, the judge considers the question of whether or not Mrs. Zhang's shareholding was non-negligible and therefore a functional link. And again, if I can ask the court please to read those paragraphs, 81 to 84. And the court can see there that the judge focused on the relative size of the shareholding in percentage terms only as the key factor in his finding that there was that the shareholding was negligible. And we say that he was wrong to do that and ought to have taken into account the monetary value. But also, and crucially we say, the judge ought to have given weight to the significant additional shareholding interest that Mrs. Zhang had as a familial interest in Chong Sing. Finally then, at paragraph 85, the judge found...
I mean, on that basis, it would make no difference, would it, to your submission, if she had one share or no shares at all?
On the facts of this case, my lord, I think that may well be right. I mean, we do say one has to look at it in the round and look at all the connecting links. But in terms of non-negligible shareholding, the key factual aspect in this case is that familial interest. And I say that it's key because, as I'll come on and show you in the evidence, that was the driver behind Mrs. Zhang giving the guarantee, being requested to give the guarantee, and indeed, objectively speaking, giving it.
Well, you can see that from the point of view of the lender, they will always want a guarantee from both husband and wife because they won't want to be met with arguments about whether the shares are held with, in one of them's name, but the other has a beneficial interest, that sort of thing.
Well, quite. And I'll come on and develop the submission, but precisely why the shareholding is listed, the familial shareholding is listed as being in her name. This is a publicly listed company, and it is of interest to potential investors which individuals control that shareholding. And for the purposes of the rules that govern what information needs to be made available to investors, a wife and a husband are deemed to have a collective shareholding for the purposes of understanding who is in control of the company. So you might well be right, my lord, that the company would want, the company seeking the guarantee would want shareholding guarantees from both husband and wife. We say there's a good reason for that, and that doesn't detract from the fact that this is a non-negligible shareholding.
So I think you're saying that in assessing whether that she has a non-negligible shareholding, you take account of the husband's shareholding.
Yes, my lady, specifically because the husband's shareholding is treated for the purposes of this company and its auditing as being a familial interest, and she is designated.
Okay, you're going to make that good by taking us to the
I am,
material.
my lady. I'm going to go through and look at the reports and the listing for the company. Just coming back to paragraph 85, the judge found there that Mrs. Zhang would have entered into the personal guarantee even if she had held no shares in Chong Sing at all. So he's effectively there saying there's no causal link between the shareholding and the guarantee. But we do say that the judge erred again because he ignored the fact that the personal guarantees were sought from each of Mrs. Zhang and Mr. Zhang only because they were the majority shareholding couple. So it's a simple point, and I will develop it. But had Mrs. Zhang had no shareholding interest in Chong Sing, she would not have been asked to be a guarantor. So,
Oh, that's contrary to what you just said when I asked you about it, isn't it?
my lord, I apologise. Then let's.
That it was probable that a lender or investor would want both husband and wife's positions to be covered.
I'm sorry, I think I should be very clear as to whether I'm talking about a husband and wife generally or the husband and wife in this specific case. And so I didn't demur from your proposition that a company may be interested in a guarantee from a husband and wife generally. I don't particularly have any submissions one way or the other on that, but in this particular case, the guarantee from Mrs. Zhang was desired because of her designation as one of the majority shareholding couple. And so the judge's conclusion that Mrs. Zhang would have been happy to sign the personal guarantee even if she had no shareholdings, we say doesn't go to the right question, because if she had had no shareholding, no guarantee would have been sought from her. So that is the judgment, and the headline points to where we say the judge fell into error. If I can now turn and look at the test at which we say the judge ought to apply to the question of consumer, as I've said, we say it's well established that the test is an objective one, and that the relevant inquiry requires you to focus on the nature and aim of the contract. And I want to make that proposition good, first by looking at the authorities, but then also coming on and look as a matter of principle as to why it is an objective test. If I can start, please, with the CJEU decision in Costea, that's at Authorities tab 38. It's page 948 in the hard copy, and I think it's page 925 in the soft copy. So this was a case in which the claimant lawyer took out a credit agreement with the defendant bank, which was secured by a mortgage over a building which was owned by the claimant's law firm. And the question referred for a preliminary ruling by the Romanian court was whether or not a person in the claimant borrower's position could be a consumer. The bank effectively argued because he was a lawyer, he had specialist skill and knowledge, which takes him outside the role of consumer, a weaker consumer. The CJEU ruled that he could be a consumer, and it held that the fact that a consumer may have a high degree of specialist knowledge as a result of his profession was not relevant where the contract entered into was not linked to his profession. And the test of the consumer was, the court said, an objective one. Now, I'd like to start by looking at the opinion of the Advocate General, not just because it helpfully explores the reasoning behind the conclusion of the court on objectivity, but because it was also adopted by the court, perhaps somewhat unusually, in the sense of cited and adopted as opposed to merely the reasoning adopted. If we can start, please, at page 954 of the hard copy, which is page 931 of the soft copy. This is where paragraph 18, the Advocate General starts by considering the concept of consumer. And if I can just draw your attention to just underneath letter D on the right-hand side, he's talking about the various circumstances in which the word consumer might appear. And he says, it is therefore a notion which is present in many areas of the European Union's legislative activity, but one which has not been specifically defined in primary law. And its application as a category for identifying certain persons is not monolithic, it is altered by each of the relevant instruments of secondary law. I just draw that to the court's attention to note that some caution must be exercised in borrowing, as it were, from the case law in relation to different community instruments where the concept of consumer might be under discussion in a different context. As we've heard, it often crops up in the Brussels jurisdictional context. There's a warning there from the Advocate General. And then over the page, the Advocate General is considering the submission of the bank that any presumption that a consumer is in a position of inequality can be rebutted if the particular consumer has necessary experience or knowledge to protect himself. If I can ask the court, please, to read paragraphs 24, first 5 lines of paragraph 25, and down to the bottom of the page in paragraph 26. So we can see there that the Advocate General is saying that the test is objective and functional, which takes into account the sphere of activity in which the transaction takes place, and which may be assessed by reference to a person's status in relation to the particular transaction. In other words, a person may be a consumer in one contract but not in another. And then going on to the next page, at paragraph 27, the Advocate General highlights that the same objective approach is taken in the case law under what was then the Brussels Convention. He says that conception of a consumer as an actor in a specific legal transaction, which entails both objective and functional elements, as the case may be, is also confirmed in the context of the Brussels Convention. And then just under paragraph C, the letter C, he quotes from the Benincasa case, which was a jurisdiction case. And he says this, or they said this: reference must be made to the position of the person concerned in a particular contract, having regard to the nature and aim of that contract, and not to the subjective situation of the person concerned. And he amplifies that in the first three sentences of paragraph 28. I can ask you to read that. So again, there he is emphasising that one is looking at the particular situation and the specific transaction which is occurring. If we then go on, please, and look at the court's decision where they approved the Advocate General's reasoning, that's at page 967 of the bundle, or 944 of the soft copy. If I can ask you, please, to read paragraphs 21 to 24. So, particularly at paragraph 21, it's an objective test in nature, distinct from the concrete knowledge the person in question has, or from the information the person actually has.
Looking at paragraph 23, where it says we have to take into account, among other things, the nature of the goods or service covered by the contract in question, that would be the goods or service being provided by the other party. That's to say, by Eternity Sky in this case.
Exactly, my lord. And it is a slightly difficult concept in the context of a guarantee. And I think, as I understand it, that's partly why there was a reference in Tarkow to try and understand actually if a guarantee situation is the sort of situation where there is a service being provided. And they said that
So what is the nature of the goods or service being provided by your client?
Well, in a broader context of the transaction, the nature of the service being provided is an agreement to sign a subscription agreement to a convertible bonds issue, in broad terms, to provide an influx of capital into Zhang.
Yes, I suppose the word nature means, or may imply, that there's scope for not being too precise about it.
Well, indeed, my lord, and part of the reason I wanted to take you through the Advocate General's opinion is because what is clear from that in our submission is that one is looking, the words which are used are not just contract uses the word transaction as reference to the contractual relationship. So one is, and the focus on sphere of activity. So one is looking broadly, not too broadly, but one is looking broadly at what is this transaction? What is this contractual relationship? What is its nature? And so it is a broader rather than narrower test. And that goes both ways. That helps protect consumers as well. But that's the inquiry which we say the judge ought to have taken, and that's the inquiry which we say you should take. Now, the approach in Costea was specifically cited and applied in Tarkow, and we see that in Tarkow, which is at tab 34. Now, the court may be familiar with the fact, but just in case, this is a case in which Mr. and Mrs. Tarkow provided a personal guarantee and mortgage over their property as security for a credit line given to their son's business by the bank. They were asked to do so by their son, judgment records, and they had no link to the company. And the court considers how to apply the consumer test in the context of a guarantee. If I can ask you to go, please, to page 911 in the hard copy, and it's page 888 in the soft copy. So at paragraph 27 at the foot of the page, the court said it should be observed that the concept of consumer is objective in nature. And they cite Costea. It must be assessed by reference to a functional criterion consisting in assessment of whether the contractual relation at issue has arisen in the course of activities outside of trade, business, or profession. So that's the point I make about contractual relation. And then if we go over the page, paragraph 28, National Court must take into account all of the circumstances and all the evidence. And then paragraph 29, we see the functional link test, which has to be applied. And we do say that a non-negligible shareholding or a directorship is a functional link to the company. There's then a separate question as to whether or not the contract is entered into because of the functional link. But once there is a finding of directorship or non-negligible shareholding, the functional link exists. So, my lords, my lady, if I can just...
Well, the contrast is between purposes relating to trade, business or profession and purposes of a private nature.
That's right, my lord. Obviously what the court has done here is given some assistance as to how purposes relating to trade, business or profession may be interpreted in the context of a guarantee. Because until this case, as far as I'm aware, that hadn't been grappled with.
Well, as far as I can see, functional links is not, as it were, not a further alternative to purposes relating to trade, business or profession, but rather an example of when such acts might qualify as so relating.
I think I probably wouldn't go that far, my lord. I think one has to give some meaning to the word or, because there wasn't the phrase such as used there. But certainly I would accept the point of the functional link test is to ascertain whether or not it can be said that the person is acting for purposes relating to trade, business or profession.
Well, you have to say that, don't you? Because that's the sole test in the directive. So the all can't mean an entirely alternative test.
No, I think that's absolutely right. Perhaps, as I understand it, what this test is getting at is where you have the directive test, the consumer rights test refers to his trade, business or profession. what the court here is saying is that in circumstances where there is a functional link between the guarantor and the company, that may be a circumstance in which the person providing the guarantee is acting in the course of trade, business, or profession. So one can take the example of being asked to do something by one's spouse for the purposes of their business. So a simple example would be, please could you go out and rent me a property for my business offices? And I go and do that because I'm happy to help out my husband. Now that is a contract in which I'm entering into for the purpose of a business. It may not be my business, but for the purpose of a business. So that's not an example in which there's a shareholding link. But I do say that one has to think in terms of the nature of the transaction, and is it for business purposes or private purposes? And in the context where I'm renting business property in my name simply because my husband's asked me to do it, but for all intents and purposes, it is for the purpose of functioning, providing a service to the business. I do say that that is much closer to the line of being operating for entering into contract for the purposes of a business.
But on that analysis, your husband and wife guaranteeing their son's loan, I mean, the loan is for the business, and therefore one would expect the CJEU to have answered it differently and say, of course they can't be consumers. Because the loan was for the business.
You know, the directive talks about his trade, business or profession. So in your example of the wife doing something for the husband's business, it's not obvious that
it isn't obvious, my lady, I accept that, but what I'm trying to do is fit in the functional link test with the overarching test of relating to his trade, business or profession. And
well, I'm not sure on the facts of this case, this is what you were saying earlier, do you really need to go beyond the facts of this case where you rely on the shareholding that Mrs. Zhang had, which you say you can effectively add together with the husband's for the purposes of assessing whether it's non-negligible, as I understand.
my lady, in my submission I certainly don't, but I was trying to grapple with my Lord Justice Males's question about whether or not the or because of a functional link was an extension of the test, a separate test, or was actually all part of the same test.
Well, we do have the benefit, if that's what it is, of a statutory definition of consumer in the Consumer Rights Act, which doesn't say anything about functional links or non-negligible shareholding. It just talks about purpose, the person's trade, business, profession. Don't have the precise words in front of me, but that's the gist of what it says. And if functional links is a separate category, then it's not one which we find in the legislation we're concerned with.
That's right, my lord. I think all I can say on this is that the functional link test is the CJEU giving an example, and I think I would have to accept that it is a slight extension of the immediate wording of the section 2.3.
Well, does it simply reflect the fact that presumably the legislation is the rule is intended to be able to be applied to incorporated businesses as well as unincorporated businesses? So it makes it clear that perhaps the fact that there is an incorporated company, so you have to look at things in terms of directorships or shareholdings, is not on its own enough to mean that you can't be acting for purposes relating to a trade, business or profession.
That might be right, my lady. I'll confess I hadn't thought about it in the context of incorporated companies as well. So I think that
well, because you know the the most immediate meaning of his trade, business or profession is exactly that. His personally owned trade, business or profession.
Yeah.
And the CJEU is clearly saying then that in some circumstances at least, it can extend to corporate structures.
I think that's right. But I think if I had to categorise the functional link test, I would say that it's an example of somebody acting for purposes of trade, business or profession, as opposed to of a private nature. So, my lords, my lady, pulling together the threads of those authorities, we say that it is clear that the test is an objective one, which looks at the nature and aim of the particular contractual relationship or transaction and the sphere of activity in which the transaction takes place. It does not look at the subjective situation of the putative consumer, but the court must, in determining that purpose or nature or aim, look at all objectively ascertainable circumstances. And in the guarantee context, a non-negligible shareholder will have a functional link to the company and therefore won't be the consumer the contract is entered into because of that shareholding. Now, just pausing there, the CMA in its written submissions to the court suggests at paragraph 34.4 that the court may take into account subjective intentions of the individual. I think that the highest that my learned friend Mr. Riley Smith goes is to say that reference may be had to the subjective intention of the individual when applying the objective test. Now, it's not clear to us exactly how that analysis works, but it certainly doesn't appear to be the CMA's contention that the subjective motivation of the putative consumer is the touchstone of the inquiry. But in any event, he cites two cases which in our submission do not support reliance upon subjective motivations of the potential consumer. Now, in the interest of time, I'm going to deal with these very shortly and give you my answers on those, and I'll deal with them further in the reply if I need to. But he relies first on the case of Haifa, which is a 2007 decision of His Honour Judge Toolman QC sitting in the High Court. That is obviously a case which predates Costea. And in that case, the question was whether or not the claimant, which was an offshore company, an offshore holding company, beneficially owned by a wealthy businessman's wife for tax reasons, was acting as a consumer when employing architects and similar contractors to carry out renovation work on a family home for the purposes of the 1999 Consumer Regulations, which was the precursor to the 2015 Act. And we say that it was obvious from the objective facts that the claimant was a consumer because the house was bought and being renovated for private purposes, simply for the family to live in it. No evidence at all that it had been bought as an investment or part of a property portfolio. And so that was the basis of the judge's decision. There was no investigation into the personal motivations or emotions of the company. Secondly, my learned friend cites a 2020 decision of Mr. Justice Andrew Baker in Ang and Reliant Co. That was a case under the Brussels recast regulation, and the judge was considering whether or not Mrs. Ang, a wealthy housewife, was a consumer when she entered into a contract with a cryptocurrency trading platform to trade Bitcoin, and she traded very large sums of money. And the point of debate in that case was really whether or not an individual investing very large sums of money can ever be a consumer. This is a point that had been considered in various European jurisdictions. And Mr. Justice Andrew Baker held that a consumer could be. Now, the judge rightly said that all of the...
Was it concerned with the status of the person investing, or was it to do with the nature of the transaction? There's quite an extended discussion in the case of whether investment in Bitcoin or other similar investments is inherently a business as distinct from private purpose. And I think in the end the judge doesn't reach any definite conclusion about it.
Well, in my submission, he looks at the question of what is the nature of the contract, he also looks, in doing that, he answers the question of whether or not she is treated as a consumer. What he does, the passage my learned friend relies upon, is that he says all of the evidence available must be taken into account, which is right. But the evidence which the judge took into account was not evidence of Mrs. Zhang's subjective motivations in seeking to invest in and to trade Bitcoin. He looked at the circumstances in which pertained when she entered into the contract. She was a housewife. She didn't have any personal trade. Yes, she had very large sums of money, but that didn't mean that she was running a business. It just meant that she was a very wealthy consumer. And his conclusion was that she entered into the contract in order to meet a private consumption need. That was the phrase he used. So that was a contract for private purposes. And she was effectively doing it as one might describe it as a hobby, to hopefully make some money. But what he doesn't
pay for holidays and luxuries and that kind of thing.
One can only imagine. But what he didn't do is look at her personal motivations. He looked at the objective circumstances. So we do say that those two cases don't support the proposition that subjective motivations are to be taken into account. And in any event, they are decisions of first instance. So, my lords, my lady, that's the position on the authorities. But we do say also as a matter of principle, the subjective motivations of the putative consumer should not be a relevant factor for consideration for three reasons. Firstly, and perhaps most importantly, it must be borne in mind, we say, that the application of the Consumer Rights Act brings with it for the trader, firstly, potential unenforceability of the terms of its contract, and secondly, the prospect of enforcement action against it by the CMA for non-compliance. A trader therefore needs to be in a position to ascertain for itself, at the time of contracting, whether or not it is contracting with a consumer, and therefore whether it has to take specific steps to ensure that its terms are fair, transparent, prominent, etc. Yet an individual's personal or subjective motivations are unlikely to be communicated or visible to the trader. So we do say that if a putative consumer's subjective motivations were to be relevant to the defining of a contract of a consumer one or otherwise, that would put traders in a very unfair position, not knowing if their contract terms would be enforceable or whether or not they might be in breach of the CRA and subject to enforcement powers. Secondly, a person may not have readily discernible motives when entering into a contract, or those motives may be mixed, or they may be in flux. But the transaction itself will always have a nature and character which can be determined by reference to objective criteria. And we say that that's why the CJEU has given two objectively determinable examples of its functional need test, directorship or the non-negligible shareholding, because that is something that can be ascertained on the evidence. Mixed motives are much more difficult to be determined, so an objective criteria is important. And thirdly and finally, Section 71.2, as we've heard of the CRA, provides for the court to intervene and to carry out an assessment of fairness of contractual terms in a consumer contract of its own motion, even if nobody has raised it. And that obligation necessarily requires the National Court to be able to identify a consumer contract in proceedings before it. In our submission, the court's only going to be in a position to identify a potential consumer contract by reference to the objective evidence before it.
Well, unless you have a situation where the consumer is regularly called and examined and cross-examined about their motives.
Absolutely. I mean, one could get into that inquiry. In my submission, in this jurisdiction, that is not a regular inquiry. But going to my point as to the court has a duty of its own motion. So in a case where a contract comes before the court and there's a contractual dispute, if the judge says, this looks like a consumer contract, they're therefore required to get into it, but they're not going to be in a position to do that because they're unlikely to have evidence as to subjective motivations being heard before them. So in conclusion, we say for all of those reasons that the judge ought to have applied an objective test and was wrong to focus on Mrs. Zhang's marital love as the purpose for which she entered into the guarantee. Just before turning to the question of how the test ought to be applied, I just want to briefly grapple with the second point of dispute, what is the correct test, which is raised by the CMA in their written submissions at paragraphs 11 to 19. Now, it is said that because the Consumer Rights Act definition of consumer uses the words acting for purposes wholly or mainly outside that individual's trade, business, etc., instead of the phrase acting for purposes outside, which is what the directive says, the proposition is the legislative intent of the Consumer Rights Act was to have a broader definition of consumer for all purposes. And so it is implied, but not said expressly, this court should construe consumer more generously than the CJEU has in Tarkow. That's the pointless point. I can deal with that very shortly with 2 points. Firstly, the wholly or mainly test in the CRA is concerned with a situation where a contract is entered into for dual purposes. So, for example, in the classic case Gruber under the Brussels regime, a farmer enters into a contract for tiles for his farmhouse roof, his farmhouse partly being used as a private dwelling and partly being used for his farming business, where it is that a consumer contract. That is a dual-purpose contract. But there is no dual-purpose contract here. So the broader scope of the CRA, if there was one, doesn't come into play in this case. But secondly, the scope of the CRA as to dual-purpose contracts is the same as that of the directive, having been interpreted by the CJEU. The CJEU applies the predominance test, which is very similar in language to the CRA's wholly or mainly test. So in conclusion, the CRA just doesn't go any wider than the directive as interpreted. In any case, we don't have a dual purpose contract. Turning then to the application of the Tarkow test to the facts, and the 2 questions. 1, did Mrs. Zhang have a non-negligible shareholding? And 2, did she enter into the guarantee because of it? We obviously say the answer to both of those questions is yes. Turning first to the question of non-negligible shareholding, there are 2 relevant pieces of evidence I want to show you in this regard. If I can ask you please to go to Supplemental Bundle tab 4. This is the 2016 annual report of Chong Sing, 2016 being the year in which the guarantees were given by Mr. and Mrs. Zhang. It's a very long document, but we only have the relevant extracts in this bundle. I'll ask you to go to page 59. You can see the chairman's statement at the top. Dear shareholders, on behalf of the board, I'm pleased to present our annual results for the year end 31st of December 2016.
The chairman wasn't Mr. Zhang.
If you go over the page, my lord, page 60, you see pictures of the directors and senior management, and Mr. Zhang is on the middle row, 1 in from the right. Non-executive director. And then if you go on, please, to page 64, see here, it's listed as the directors and chief executives' interests, short and shares, etc. Third entry down in the left-hand column is Mr. Zhang. And then you see in the 1 column in, he has 3 interests. 1 as beneficial owner, 2 as an interest in a controlled corporation, that's reference to a company called First Pay, Mr. Zhang owned. First pay owned those shares. And then there's the family interest, which is the 90 million shares of Mrs. Zhang. And if you note next to where it says 90 million, you see the numbers 4 and 8, and those are the notes. And we get the notes on the next page. On page 65, note 4 says these shares were held by Mrs. Zhang, who is the wife of Mr. Zhang. Therefore, Mr. Zhang was deemed to be interested in these shares under the SFO, which is the Securities and Futures Ordinance, which contains, amongst other things, the rules for listed companies in Hong Kong.
Does it say that Mrs. Zhang was interested in his shares?
So this is Mr. Zhang at the moment. I'm
Yeah.
just highlighting in the note the reason why the family interest is why her 90 million shares are recorded as a family interest. And the reason is because he's deemed interested under the Securities and Futures Ordinance. And then if we go over the page, please, to page 66. There we have substantial shareholders and other persons' interests in the underlying shares. And their second entry down in the left-hand column is Mrs. Zhang, and you see her beneficial owner of the 90 million, and then her family interest of the 3.8 billion shares, which is the combined total of Mr. Zhang's personal shares and his first pay shares. And then if you go across to the right-hand column, under the heading approximate percentage of the company's issue shares, she is recorded as having 18.27%. Now, I am afraid that we don't have in the bundle the notes, the next page that has the notes to explain the family interest. But it does say the same point as you saw with Mr. Zhang, which is that she's deemed to hold them under the SFO. I'm afraid we just don't have the next page in the bundle. So, just pausing there, the court will note that the auditors of the company, complying with the Hong Kong financial disclosure laws, first consider it proper to record Mrs. Zhang's familial interest via her husband's shareholding as being hers. Second, treat her as a substantial shareholder. And third, record her interest in the company shares as being 18.27%. And we get the same from the listing form of Chong Sing on the Hong Kong Stock Exchange. That's in the same bundle at tab 10. So this is a form relating to the listing for GEM, which is the Growth Enterprise Market on the Hong Kong Stock Exchange. In the substantive paragraph in the middle, it says this information sheet contains certain particulars about the above company. These particulars are provided for the purpose of giving information to the public with regard to the company in compliance with the rules governing the listing of securities on GEM. Now, I do note from the next line that the information in this sheet was updated as of 5th of May 2020. And at the bottom right-hand corner, you can see that it's dated February 2018. So I don't say that this is on the time that the guarantee was entered into, but we've seen from the report what the position was. But it's really going to how the shareholding is presented to the public. And you see over the page, again, top left, it says names of substantial shareholders as such term is defined in Rule 1.01 of the GEM listing rules. And in the list of names, Mrs. Zhang comes in at the bottom, and she's given as beneficial owner of 0.39% of the issued shares and a family interest interest of 16.6%. The precise amount of the family interest is slightly different, but it is still substantial. My lords, my lady, I was then going to turn to my points of submission. I'm conscious of the time. I don't know if the transcriber might.
Yes, how are you doing?
I think it will be 10 to 15 minutes.
Yes. All right. Well, we'll take a 5-minute break.
For some reason, I just think put it before Brian, hasn't it been evidential questions that they didn't appreciate burdens on the traders established.
Hi, Adam. Yeah, there's an issue with the transcripts. No, I'm not going to write it. No, I have, but there's nothing to worry about. No. I was hoping maybe we would just restart and maybe.
Admitting that you were right.
Oh, we've prepared the application.
Probably because it took so long to respond to the client.
Well, it might be worth drawing it up, I suppose.
Is your editor? We thought we'd assist. Yeah, I'm still to reach out. Obviously, you were right in, so I didn't expect a response from you. Sorry for the complications, Adam. No, it shouldn't be anything to do with the hardware. No, I can't really say. You okay? Yes. Okay. How has the internet been? Has it been consistent?
Our activity without an individual payment cycle in the hope of making large investment gains at the risk of suffering the effects of the war.
Maybe a bit slow. Okay. Is your editor having any issues at all? Eclipse. Okay. Are you getting green light or Eclipse? Maybe the blue line. I'm just gonna. That's what I'm currently seeing on my transcript. No, I think we're okay.
It's amazing how many of the points are.
Yeah.
So how many of the points come up on the field is amazing, and they're just a little bit beyond on the other.
No sense which is
It's fine. It's reassuring when it's nodding. I was like, okay, fine, I've obviously got that. You did a big shake. Like, oh, no. No, you didn't. I was just, if you were saying,
Of course, yeah.
So I don't think we're going to get to you till before lunchtime. So we go back to public shop on ground floor. Oh, I see. Then to leave it, to reply on ground floor. No.
Are you ready?
We have done 5 minutes. Thank you. Maybe 2 minutes.
Just
2 minutes. Apologies.
What's the problem? What's the problem? Walks. Well, for them, not for us.
Yeah. I'm just going to
And then maybe the question of the degree of having no involvement or her being like you. And being a shadow director. It's difficult because they are the facts. Weren't the facts.
not really supposed to do that, are you?
Yeah, well. Yeah, I mean, it's just if nobody else has mentioned it, it would be a travesty.
My lords, my lady, so those are the basis for the substantial shareholder. That's the evidence on which I rely. Turning then to my points of submission on non-negligible shareholding. First, we do say that the significant percentage of that familial shareholding is a highly material factor in determining whether or not she has a non-negligible shareholding, and which we say that the judge wrongly failed to give weight to. We just looked at Chong Sing's accounts, which, in accordance with Hong Kong law, both consider it appropriate to treat Mrs. Zhang's shareholding as a combined familial interest and record her as being a substantial shareholder. And we say that that reflects the reality of the position, which is that Mr. and Mrs. Zhang is a family unit with a majority shareholding couple. Taking a granular approach to the precise beneficial ownership of those shares is not one which is used in practice, as we can see, to ascertain who has an interest in the shares of a company and where control lies. It doesn't reflect the position looked at from the outside objectively. Again, consider the diligent trader who wants to be CRA compliant. And the prudent trader doing his homework looks at the Chongqing publicly available accounts and sees that Mrs. Zhang is a substantial shareholder. In those circumstances, the diligent trader is not going to think that he is contracting with a consumer. Second, we say that the court ought to have given weight to the absolute value of the shareholder at the time that she provided the guarantee. The sheer size of Mrs. Zhang's financial interest, worth some £5 million at the time, meant that she had a significant and not negligible amount of money resting upon the success of the bonds issued in the subscription agreement. Again, looked at objectively, if one is the diligent trader doing one's homework, and you identify that a potential guarantor has a shareholding in the company of £5 million, especially in the context of a bond issue worth about £50 million, the diligent trader is not going to think that that person has a merely negligible shareholding. One is always reluctant to ask the court to apply the common sense test, but certainly the average person on the street is not going to think that a shareholding worth £5 million is negligible. Now, the judge, in his judgment at paragraph 82, said that the approach of Mr. Justice Andrew Baker in Angan Reliant Co. was relevant here to say that the quantum of the sums at stake in the shareholding shouldn't be the focus of the inquiry. But in Ang, his lordship held that the fact that a person was very wealthy and was investing large sums of money did not stop them from being a consumer when engaging in trading a cryptocurrency. So effectively, the argument was put from the other side that the sums being invested were so vast, one has to treat it as being done for a business purpose. And Mr. Justice Andrew Baker in our submission rightly said no. But that analysis in Ang is not a basis for also saying, as the judge did below, that looking at the quantum of the sums at stake when assessing whether or not a shareholding is negligible is the incorrect approach. With respect, the reasoning Ang has no bearing on that question. Mr. Justice Andrew Baker was simply not concerned with it or anything like it. So we say you can't derive any assistance one way or the other from Ang. And we also say that the judge was wrong to rely, as he did at paragraph 84, upon the fact that Mrs. Zhang's personal shareholding was much smaller than Mr. Zhang's and dwarfed by it. In our submission, that comparison is irrelevant. The fact that Mr. Zhang's individual shareholding value was ginormous didn't prevent Mrs. Zhang's from being significant. So, my lords, those are my submissions on why Mrs. Zhang's shareholding was non-negligible and a functional link. Turning then to the key question in our submission, was the guarantee entered into because of that? As I've said, the judge's focus in our submission on Mrs. Zhang's subjective motivations of love and a desire to act upon her husband's wishes as his wife was wrong. In our submission, it cannot simply be sensibly said that the objective purpose of the guarantee was love or marital duty. And as I've said, the court needs to look at the nature and the aim of the particular contractual relationship and the sphere of activity by reference to all the objectively ascertainable circumstances. And in this case, we say there are three particularly relevant circumstances. First, the general nature and aim for which the guarantee was entered into, and its sphere of activity, i.e., securing a subscription by Eternity Sky to a bond issue by a listed company in which Mrs. Zhang was a major shareholder in a corporate setting. Second, the fact that Mrs. Zhang in particular gave the guarantee, as opposed to any wealthy person who was willing, because she was one of the majority shareholding couple. And third, and we do say this is an ancillary point, but a relevant one nonetheless, third, the fact that there was a significant individual and familial financial interest to Mrs. Zhang in the bond issue being secured by the subscription agreement. Turning then to look first of those factors that we say are relevant, the nature and aim of the guarantee transaction. I can ask the court please to look at paragraph 145 of the judge's judgment. It's at page 103 of tab 5 in the court. What we actually see there, this is the section of his analysis on average consumer. And what he says at paragraph 145 is the analysis we say he ought to have brought to bear when looking at the purpose of the contract. So he says, 3 lines down at paragraph 145, what I should have in mind is the average consumer who might enter into a consumer contract of this particular type. I must do so bearing in mind both the nature of the transaction, a personal guarantee for obligation under a subscription agreement for a very substantial bonds issue, and the context, which was essentially corporate, involving a company listed in Hong Kong with a major subscriber to the Hong Kong bonds issue. It is not only different from a typical consumer contract, the consumer is providing a guarantee, it is even different from a typical personal guarantee because of the corporate Hong Kong context. So, my lords, my lady, we do say that is the sort of analysis which the judge ought to have done in the context of determining purpose. So, I can put it a different way. In this case, the sphere of activity or context in which the guarantee is given is the raising of capital for a listed company, which is undoubtedly a corporate context. Chong Sing, a listed company, required or desired an influx of capital, and Eternity Sky was prepared to give that by way of subscription to a bonds issue only if it obtained guarantees from the majority shareholders. Guarantees were given to a company in the support of business of another company by both of the majority shareholding couple. The nature of the guarantee was therefore necessarily a corporate one, given in support of the functioning of a listed company. And similarly, the aim, as we touched on earlier, the aim of the guarantee was to encourage Eternity Sky to subscribe to the bonds issue in Chong Sing and therefore ensure the flow of capital. Again, it's an entirely business or corporate aim. It's not given to fulfil any private need or consumption. The words used by Mr. Justice Andrew Baker, which in my submission are quite helpful. So then, why Mrs. Zhang herself gave this guarantee? The crucial distinction in our submission, in this case from those such as Tarkow and Dumitras, is that there was a guarantee between Eternity Sky and Mrs. Zhang, not merely because she had means, and because her husband required a loan, but because of her role as the majority shareholding couple. That's her functional link, and the functional link was the cause of the guarantee being entered into, not the marriage. I want to make that point good by looking at the evidence. If we can go to supplementary bundle tab 3, please. This is the personal guarantee. And on the next page, page 38, and we see from preamble C that it was a condition precedent to the subscription agreement that Mrs. Zhang provide the guarantee. So no Mrs. Zhang, no subscription agreement, and no capital influx for Chong Sing. And then if we go on, please, to page 46, Clause 5.1 of the guarantee sets out various undertakings, and these are relevant, we say, because they show how Mrs. Zhang was treated. You see first in 5.1a, first undertaking is the guarantor and her spouse shall ensure that their net worth shall not be less than 5.4 billion Hong Kong dollars. So note there that the guarantor and her spouse are treated as a single entity. Similarly, in subparagraph B, the guarantor and her spouse are required to provide net asset certificates on a regular basis. And then C, which we say is crucial for the objective inquiry, the guarantor shall ensure that she, together with parties acting in concert with her, shall continue to be the single largest shareholder in the company. So we say that the terms of the guarantee are clear, that the guarantee was being given in the context of Mrs. Zhang being considered to be a single largest shareholder. And that conclusion is supported by the evidence of what Mrs. Zhang was told at the time. In the same bundle, I can ask you please to go to tab 1. These are the WeChat messages which were sent between Mrs. Yu, Mr. Zhang's assistant, and Mrs. Zhang on the 6th of May 2018, in which Mrs. Zhang was asked to provide the guarantee. The English translation is at page 4, and you can see in the right-hand column the message from Ms. Liu. She says, Xiaomin's sister, the listed company Credit China is issuing bonds, requires majority shareholding couple to provide guarantee. The contract tomorrow morning after reaching an agreed form will be signed. And then she goes on to say what she needs signing and sending back. So we do say it's clear that Mrs. Zhang knew that her shareholding is the reason for her being asked to provide the guarantee. I probably don't have time to take you to it, but the arbitrator also found at paragraph 75 of the award that Mrs. Zhang intended to provide the security in order to bring about the issuance of the bonds. And at paragraph 142, she gave evidence that she signed the documents as part of her husband's business. So to summarise, Mrs. Zhang may well have loved her husband, but that was not the objective purpose of providing the personal guarantee. It was provided solely because of her position as majority shareholder, because of that functional link with Zhang Xing. She may be internally motivated by auxorial duty, but objectively speaking, that wasn't the purpose that this guarantee was fulfilling. Or, thinking about it in terms of causation, the legally effective cause of the guarantee being concluded between Mrs. Zhang and Eternity Sky was her shareholding. It was not love or marital obligation. And this case is not comparable to those typical consumer guarantee cases where a family member who is willing and has available assets, such as the parents in Tarkau or the wife in Dumitras, gives the guarantee because they're asked to do so by their son or their spouse. We are many miles away from that, and it's clear, we say from the evidence, that Mr. and Mrs. Zhang were the only show in town for the purposes of this guarantee agreement. What Zhang Xing, what Eternity Sky wanted for the purposes of entering into the subscription agreement. So, my lord, coming back to your point earlier, that there may have been other contexts where Mrs. Zhang was willing to sign documents in a company which she had no shareholding. That may well absolutely be right, but for the purposes of analysing whether she's a consumer in the context of this transaction, it's the specific features of this transaction which we say the authorities make it clear the court has to have regard to. And then our very third and final relevant factor, we say, is that it is an obvious inference to be drawn that where a person has a direct and significant financial interest through a large shareholding in a company and offers to guarantee that company's obligations to ensure that the company's working capital increases, that person's personal financial interest in supplying the guarantee is a relevant factor, which supports the conclusion that the purpose of entering into the guarantee was to support the company and not for private reasons. And the judge recorded in paragraph 74 of the judgment that Mrs. Zhang no doubt hoped that the bonds issue would generate a degree of wealth. So that's an ancillary factor, but we do say it's a relevant one. My lords, my lady, unless I can assist the court any further.
No, thank you very much indeed. Back to you now, Mr. Lewis, is it?
It is, thank you. I am slightly on borrowed time, but
Yes.
I do have one point of substance to finish with and of interest to the arbitration community in particular. The sixth reason why the appeal should be dismissed, even if Clause 2 infringed the CRA, enforcement should still not be refused. This is a point of principle as to the nature of the discretion under Section 103(3) of the Arbitration Act. We have three headlines. First, Section 103(3) involves a balancing exercise between two competing policies, the pro-enforcement, pro-arbitration policy on the one hand, and the countervailing public policy being invoked by the award debtor. Secondly, on the facts of this case, that balance should come down in favour of enforcement, given Mrs. Zhang's extreme and unmeritorious position. Thirdly, the decisions of the CJEU do not mandate any different result. Alternatively, if they do, they should be departed from post-Brexit. Before I deal with those in turn, I wish to guard against two misapprehensions. First, we accept that infringements of the CRA can qualify as public policy under section 103(3), and that they will do so more often than not in everyday consumer cases. The question is whether they should always or almost always do so, or whether there should, as we say, be a more open-textured balancing exercise. Secondly, contrary to judgment paragraph 201, we do not say that the CRA is second-tier public policy, whereas pro-enforcement, pro-arbitration bias is first-tier. We say they are both first-tier, hence the requirement for a balancing exercise.
So this question arises, I take it, on the assumption that Mrs. Zhang is a consumer, that there was a lack of transparency, and that clause 2 is unfair.
Correct.
Yes. Right. Okay.
And the first headline is that on that hypothesis, one then has to weigh those factors and the public policy in favour of the CRA against the public policy in favour of arbitration and enforcement of foreign arbitration awards. We rely upon numerous authorities to make good the importance of enforcement of foreign arbitration awards and the balancing exercise at paragraph 68 of our skeleton. Given the time, I will emphasise just one. That is the RBRG and Sinocor case, which is in Authorities Volume 2, tab 44, please. The facts start at paragraph 4 on page 1067, and one does have to understand them in a little detail. RBRG had agreed to buy Mexican steel coils from Sinocor CNF China. The shipment period was July 2010, payment by letter of credit. Goods were loaded on 5th, 6th July, and genuine bills of lading were issued. RBRG then procured an unjustified amendment to the letter of credit, requiring shipment to be 20th to 30th of July. Sinocor then presented forged bills of lading, dated the 20th and 21st July. But the letter of credit did not pay out, and Chinese proceedings against the bank were later dismissed because the bills of lading were fraudulent. Sinocor terminated the sale contract and obtained a CTAC award for damages, having diverted the goods to another buyer in Houston. The tribunal found that the fundamental cause of the termination was the wrongful amendment of the letter of credit by RBRG in breach of contract. One sees that at paragraph 13, subparagraph 7 on page 881 of the report. So RBRG then resisted enforcement of that award in the UK on the basis that their counterparty had attempted a fraud on the bank. That failed at first instance and on appeal. The Court of Appeal considered the interrelationship between illegality in the performance of the underlying contract and enforcement of the award. We pick up, please, at paragraph 24 on page 884 of the report, where Lord Justice Hamblin, with whom Lord Justices Irwin and Lewison agreed, endorsed a summary of principles from Dicey and Morris. The first sentence: English law recognises an important public policy in the enforcement of arbitral awards, and the courts will only refuse to do so in a clear case. There are then various propositions. Between F and G is the third proposition, which is that it is important to distinguish between domestic public policy in English law and considerations of international public policy applied by the English courts, so as to disapply foreign law or refuse to enforce an arbitral award, as the case may be. Thus, the mere fact that English law would have arrived at a different result does not of itself justify the application of English public policy. Towards the bottom of the page, penultimate line, is the sixth proposition. Sixth, the court has to perform a balancing exercise between the finality that should prima facie exist, particularly for those that agree to have their disputes arbitrated, against the policy of ensuring that the enforcement power of the English court is not abused. The nature of and the strength of the case for illegality, and the extent to which we've seen that the asserted illegality was addressed by the tribunal, are factors in the balancing exercise between the competing public policies. The pro-arbitration bias is picked up again at paragraph 25, subparagraph 1, further down that page, with the citations from Deutsche Schachtbau and IPCO Nigeria. Over the page at paragraph 25.4, Lord Justice Hamblin goes on to say, in considering whether, and if so, to what extent public policy is engaged, the degree of connection between the claims sought to be enforced and the relevant illegality will be important. Then over the page, the judge is rejecting a submission that Patel and Mirza should be applied in this context, and says at subparagraph 26.3 on page 887, there are sound justifications for taking a different approach to substantive claims and enforcement claims, reflecting the different role performed by the court in each circumstance. And then applying those principles at paragraph 30 on page 889, Lord Justice Hamblin said, in my judgment, there are a number of reasons why the degree of connection between Synacor's fraud in presenting forged bills and its claim for enforcement of the award is not sufficient to engage public policy, or if it is engaged, to justify refusal of enforcement on public policy grounds. And that conclusion was followed through at paragraph 40 on 891, where the public policy considerations relating to illegality were outweighed by the interests of finality. We said there's nothing special about illegality. It's not big and it's not clever, one might say. It's no different to other types of public policy. All public policy arguments should engage a fact-sensitive approach. All should engage this balancing exercise to see if the particular public policy in the circumstances of the case outweighs the pro-enforcement policy. So our second headline proposition is that Mrs. Zhang is undeserving of a refusal of enforcement, even if she has established that Clause 2 is unfair under the CRA. This is a reflection of the extreme facts of this case. The court should weigh the pro-enforcement policy more heavily than the CRA policy, which has led on this hypothesis to that determination of unfairness of clause 2. We rely upon 4 matters. 1, Mrs. Zhang commenced the arbitration under its governing law, seeking to set aside the PG and clause 2 inter alia on grounds that it was an unconscionable bargain, which is not overall dissimilar to the arguments of unfairness. Point 2, the PG was found by the tribunal not to be unconscionable, and so to be a fair and enforceable bargain between an intelligent, well-informed and extremely wealthy woman and a Hong Kong company lending to the business in which she was majority shareholder couple. If she has got as far as this, it is on, we would say, a number of technicalities as to close connection, consumer transparency, etc. Whatever its shortcomings,
Well, I mean, plus the essential one, which is unfairness. How does the arbitrator's finding that the transaction was fair fit with the assumption that the clause was unfair?
I don't say it was the same question. The test for unconscionability that he applied is different to the substantive unfairness test. I say that they're similar questions, but that does lead on to my third point, which is whatever the shortcomings of clause 2 assessed as at the date of guarantee, it has not in fact operated unfairly. And this question, weighing the competing public policies, is a question to be assessed at the date of the hearing before this court. Mrs. Zhang has not been treated unfairly in being held liable for the principal sum of $500 million less a minor payment that had been made, plus 7% interest. In particular, fairness has already been moderated by the claim for default interest being disallowed by the tribunal as penal. That's Award 198. Fourth point. Even if clause 2 lacked transparency and was unfair for the objective average consumer, the same did not follow subjectively for Mrs. Zhang, given the tribunal's finding in relation to her awareness of her risks and obligations. And we have footnoted in our skeleton at footnote 16, page 61 of the core bundle, the award references we rely upon to say how Mrs. Zhang should not be able to say, well, the objective relevant average consumer would have been hard done by, because she was not in fact hard done by. We say in those circumstances the CRA shield cannot outweigh the pro-enforcement policy. And we say there is still relevant the test of Sir John Donaldson, Master of the Rolls, in the Deutsche Schachtbau case, which we quote at paragraph 68.5 of our skeleton. The ordinary, reasonable and fully informed member of the public would not be in the least offended by enforcement of this award. Rather, the public would be surprised if Mrs. Zhang could evade her award debt based on consumer rights. So I come to my third and final headline, namely that decisions of the CJEU do not mandate any different result. Alternatively, if they do, should be departed from. Two decisions to show, my lords and my lady, briefly. The first is Mostaza Claro, on which the judge relied. That is in the first authorities bundle, tab 21, page 467. This case does not establish any rule about the overriding nature of consumer rights when up against the pro-arbitration, pro-enforcement public policy. It only establishes that EU law-derived consumer rights protection should rank and be treated equally with other English law public policies. Ms. Claro had defaulted on her mobile phone contract and its minimum subscription period, and a Spanish arbitration award was obtained against her after she participated in the arbitration without raising any consumer point. She then sought annulment of the award before the Spanish court, raising for the first time unfairness of the arbitration clause. The national court considered the arbitration clause to be unfair. The CJEU was asked whether or not the Spanish court had power to annul where she had not raised the consumer point before the tribunal. Again, this was not a New York Convention case of cross-border enforcement. If we pick up, please, at page 483, paragraph 24, the court starts by emphasizing national procedural autonomy, before indicating that national procedural autonomy in terms of ensuring protection is subject to the no less favourable principle of equivalence as well as the principle of effectiveness. The latter requires that it not be impossible in practice or excessively difficult to exercise the rights. At paragraphs 33 and 34 on page 485, the mobile phone company and Germany argued for a limited review of arbitration awards, but at 35, the court's response was to rely upon the earlier EcoSwiss decision, which we've analysed in our skeleton, and to say that where domestic rules of procedure require a national court to grant an application for annulment of an arbitration award where such an application is founded on failure to observe national rules of public policy, it must also grant such an application where it is founded on failure to comply with community rules. That is the principle of equivalence. It is not saying that consumer rights must always trump. It is saying that EU law-derived consumer rights must be given equivalent status and effect to national rules of public policy. That is further demonstrated by the second and final case, Asturcom.
Sorry, before you read that, how do you then reconcile your submission with paragraph 39, which says you must annul where there's an unfair term? I mean, in fact, it should say unfair term which has been material to the award, but that's implicit in what it says.
Well, that's on the basis that national rules of public policy, if violated, would lead to annulment, and therefore a violation of a community rule, which is to be given equal status and effect, should have the same consequence. And what we see in the Asturcom case, which makes clearer equivalence, is that other policies can override consumer rights, and in particular the policy of res judicata. So for that, please, it's Authorities Volume 1, tab 31, page 822, hard copy, or 799, soft copy. This was another Spanish mobile phone contract arbitration award. The consumer here did not initiate annulment proceedings within a 60-day time limit, so the award became final. the mobile company then brought domestic enforcement proceedings, the National Court asked whether it had to assess fairness of the arbitration clause of its own motion, notwithstanding the lack of a timely annulment proceeding, and the answer was no. Consumer rights could be trumped by the principle of res judicata and finality. There was no absolute protection. We pick up, please, page 847, paragraph 33. And this is where the court distinguished Mostaza Claro, because Mrs. Rodriguez Noguera did not in any way become involved in the various proceedings, not the arbitration, nor did she bring an application for annulment. Paragraph 34 then raises the question of whether the need to replace the formal balance which the contract establishes with an effective balance, i.e. consumer protection, requires the court or tribunal responsible for enforcement to ensure that the consumer is afforded absolute protection, even where the consumer has not brought any legal proceedings. In order to assert his rights, and notwithstanding the fact that the domestic rules of procedure apply the principle of res judicata. So paragraph 35 through 37 then go on to talk about the competing policy here, res judicata, and how that is recognised as a legitimate public policy. And at paragraph 38, they explain how res judicata can trump consumer protection, provided there is compliance with the principles of equivalence and effectiveness. Paragraphs 46 and 47 over the page, they go on to find that the 60-day time limit for annulment was consistent with the principle of effectiveness, because it would not make it virtually impossible or excessively difficult to exercise the right. Paragraph 49 is where the court turns to the principle of equivalence. And at 52, the court reiterates what that means, that the Consumer Directive must be regarded as a provision of equal standing to national rules which rank within the domestic legal system as rules of public policy. At 53, it follows that inasmuch as the National Court or Tribunal sees of an action for enforcement is required in accordance with domestic rules of procedure to assess of its own motion whether an arbitration clause is in conflict with domestic rules of public policy, it is also obliged to assess unfairness. And that shows again the equivalence. And then at paragraph 59, the reverse conclusion from Mostaza Claro, the directive must be interpreted as meaning that a court or tribunal hearing an action for enforcement of an arbitration award which has become final and was made in the absence of the consumer is required, where it has available the legal and factual elements necessary for that task, to assess of its own motion whether an arbitration clause is unfair, insofar as, under national rules of procedure, it can carry out such an assessment in similar actions of a domestic nature. If that is the case, it is for the court or tribunal to establish all the consequences thereby arising under national law in order to ensure that the consumer is not bound by the clause. The conclusions are summarised at paragraph 77 of our skeleton. Consumer rights are not absolute. Enforcement may proceed uninhibited, even where relevant clauses are unfair. EU-derived consumer rights do not need to trump pro-enforcement policy unless national rules of public policy would also trump the pro-enforcement policy. The national court must respect the principles of equivalence and effectiveness. Insofar as our national procedural rule is a balancing exercise, as per RBRG in this court, then that is what is required for equivalence when here we are weighing the CRA against pro-arbitration policy.
But paragraph 59 at the end does make it clear you can't bind the consumer to the unfair clause. I mean,
No.
RBRG, the fraud had nothing to do with the actual award, and that was the whole purpose on which they said the fraud is neither here nor there.
No, we don't accept that interpretation of paragraph 59. What it's saying is, if under national rules of procedure, an equivalent public policy would lead to non-enforcement, then non-enforcement must follow because the clause is not binding. But when one reads it in the context of what's gone before, res judicata is a valid policy and finality can trump. And it is because the CJEU always stops short of deciding the case on its facts, it remits to the national court to ensure that there is equivalence and effectiveness. But it's not saying that the consumer protection rights must be enforced. Quite the opposite. They're not absolute. It's saying they must be enforced to the extent of equivalence and effectiveness, i.e., if the same result would follow with comparable national rules of public policy.
But the Consumer Rights Act says in terms that an unfair term of a consumer contract is not binding on the consumer. Well, if we enforce the award, doesn't that mean that Clause 2 is being treated as binding on the consumer?
Yes, and that goes back to what we looked at in RB and G. That would involve approaching this enforcement case as if it was a substantive claim. It's not. It's different in principle. The result can be different on enforcement than it would be if the case had been decided fully in this jurisdiction. If it had had a London High Court jurisdiction clause, then Mrs. Zhang may have argued the CRA at the same time as unconscionability and the other points. Here we are in a different scenario, and one therefore, provided we comply with equivalence and effectiveness, undertakes a balancing exercise. On the one hand, yes, that provision of the CRA, as with others, reflects English public policy. But the court is not obliged to enforce that public policy as first tier and put pro-arbitration second tier. It has two first tier policies and it weighs them in the balance.
Can I just put this proposition to you, which is that understanding all that, but if you've lost all the way down, say that this is part of English law being applied, the statute then says it shouldn't be enforced. And where you have two first-tier public policies floating around and the court to choose between them, we must obey the statute.
I don't accept that because ultimately there's a discretion under section 103.3 of the Arbitration Act, and this court is not obliged to obey the statute and ignore the pro-enforcement, pro-arbitration policy that arises out of the case law. Just as with illegality, this court does not routinely ignore illegality, but it weighs in the balance the different considerations. There can be, and we say if we've got this far, this is one, technical infringements of the CRA. And it does not follow whether from the CJEU jurisprudence or from a comparison between case law-based pro-arbitration policy and the CRA that the technicality is an irrelevance. The CRA does not always trump. So we say one should apply the RBRG approach and doing so is sufficient for equivalence and effectiveness. And there is nothing in the European jurisprudence that says otherwise. Indeed, that is what it mandates. The last point only arises if I'm wrong on the foregoing, and Mostaza Claro and Stuacom mandate that consumer rights always trump. And on that hypothesis, we say they should not be followed. In particular, Mostaza Claro should not be followed under Section 64B and BA of the EU Withdrawal Act 2018. That allows this court to depart from those decisions in line with the Supreme Court test for departing from its own decisions, namely if it is right to do so. And we say it is right here, so that the English courts can regain flexibility and only refuse enforcement in deserving consumer cases. Mrs. Zhang's case is not such a case. Unless there are any questions.
Thank you very much. Yes, Mr. Kerr.
I think we're in Mr. Finch's hand, and I promised to give him this lectern, so forgive me. I didn't want to interrupt a learned friend.
My lords, my lady, it falls to me to answer the question of whether Mrs. Zhang was a consumer. We say Eternity Sky's argument is wrong for 5 interrelated reasons. Firstly, the starting point is the statutory definition of consumer, and whether Mrs. Zhang was acting wholly or mainly for the purposes of her trade, business, craft or profession. Mrs. Zhang had no trade, business, craft or profession, and was not so acting. We say the concepts of functional link and non-negligible shareholding need to be read in the context of that test. Second, when an individual signs a personal guarantee in relation to a company's obligations, we accept that they may be acting for the purpose of their business if they have a functional link to that company. We further accept that a functional link may be identified by a directorship or a non-negligible shareholder. But Mrs. Zhang held no directorship, and we say that her shareholding of just 0.4% was negligible. Ultimately, Mrs. Zhang had no functional link to Chongqing. Third, the fact that Mrs. Zhang had a financial interest in the bond issue through her 0.4% shareholding does not mean that she was acting for the purposes of her business. The authorities are clear that having a financial interest in a transaction does not determine whether or not one is a consumer. Fourth, we say that determining whether an individual is acting for purposes wholly or mainly outside their trade, business, craft or profession inevitably involves an analysis of the individual's motives and intention for entering into that transaction. The judge was therefore right to identify Mrs. Zhang's individual motivation in entering the personal guarantee. Fifth and finally, as the judge found, Mrs. Zhang entered into the personal guarantee because, or at least primarily because, of her marriage to Mr. Zhang. That is a private, personal purpose, and therefore qualifies Mrs. Zhang as a consumer. Turning then to the first submission, the starting point. We might turn the court to section 2.3 of the Consumer Rights Act. That's in Authorities Bundle Divider 9, page 88, electronic page 93. We can see there that consumer in statute means an individual acting for purposes that are wholly or mainly outside the individual's trade, business, craft or profession. I just pause there for a second on wholly or mainly. This was a change introduced with the CRA in 2015. It was not in the predecessor legislation and does not derive from the directive. The insertion of those additional words followed a joint proposal by the English and Scottish Law Commissions on the basis that the previous definition, and the way it had been interpreted by the European courts, was too narrow. And we can see that at Authorities Divider 55, page 1525, electronic 1502. And if I could invite the court to read the marked passage there, 6.11 to 6.13.
Sorry, 6 point.
6.11, my lord.
Thank you.
This is a point picked up by the CMA in their written submissions, and we agree with those submissions. Our position is that Mrs. Zhang would qualify as a consumer under the stricter definition as applied in the European jurisprudence, including Tarkau on personal guarantees. But it's right, of course, that those cases need to be read in the context now of that broader definition. I'll return to that when I turn to our fifth submission. But now on point 1, it's sufficient to note that Mrs. Zhang had no trade, business, craft or profession. You can take that from paragraph 63 of the judgment. And it follows that prima facie she could not have entered into the personal guarantee for such purposes. That is why Eternity Sky rely on the shareholding. Because it is for Eternity Sky to establish that Mrs. Zhang was not a consumer, the burden being on them under section 2.4 of the Consumer Rights Act. They need to show that Mrs. Zhang had sufficient connection with Chongqing to make providing the personal guarantee over Chongqing's liabilities the furthering of her business interests. We say that they fall short. That brings me to our second submission, the functional link. If I could turn the court back to the relevant passage from Tarkau, which is paras 29 and 30, Authorities Divider 34. Page 912, electronic page 889. This is a passage which my learned friend took you to, and I don't intend to read it out again. We make 3 points on this passage, which is where the functional link appears for the first time. First, the Court of Justice is not looking to rewrite the directive. That is not its role. It's seeking to give purposive effect to the directive definition of consumer in the context of a personal guarantee. It is looking to determine when it is appropriate to treat a guarantor as acting in a manner which is akin to furthering his own trade, business, craft or profession, such that he ought not be viewed as acting for private purposes. Second, the focus is on functional links, or as it is phrased in paragraph 30, links of a functional nature. The reference to non-negligible shareholding is an example given in that context. And when the court turns to determine what a non-negligible shareholding is, we say it is important to remember that the ultimate question is whether that shareholding provides a functional link such that it is right to effectively view the guarantor as acting for their business purposes. Third, turning to what the Court of Justice's reference to functional link is designed to cover. We say it's designed to cover the situation of individuals such as Mr. Zhang. There was an incorporated company, Chongsing, but Mr. Zhang was still the controller and operator of it. He was the large minority shareholder, a director, and the ultimate controller. It was, to all intents and purposes, his business. And that's what Tarkow is looking at, we say. We say it's looking to avoid that argument that it's not my business, it's a separate legal entity. It says, well, no, in those circumstances, it's right, because of the functional link, to treat the business activities of the company as the business activities of the individual guarantor. We say it's not designed and does not cover Mrs. Zhang's circumstances. Turning back to the facts of this case, the question for Mr. Justice Bright below was therefore whether Mrs. Zhang had a functional relationship, a functional link to Chongsing. He concluded that she did not, and we find that at paragraph 83 of the judgment. We say the judge was clearly correct. But pausing there to look at the size of Mrs. Zhang's shareholding, this is a point that my learned friend makes. We say it's wrong to look at the combined shareholding of Mrs. Zhang and Mr. Zhang. Whilst they may be referred to as the majority shareholder couple, and whilst Chongsing's annual report and listing documentation identifies Mrs. Zhang as having a familial interest in Mr. Zhang's shares, that is, as my learned friend identified, a result of a deeming rule in the Securities and Futures Ordinance. It does not change the practical reality of what Mrs. Zhang owned, nor provide her with a role in, control over, or a functional link to Chongsing. Taken to its logical conclusion, Eternity Sky's argument would mean that any spouse, even if they didn't hold any shares, would have a functional link with their partner's company, such that if they signed a personal guarantee, it would be furthering their business interests, despite having no personal shareholding, no role, no link. We say that can't be right. It follows that we say the relevant percentage is 0.4%. Those were Mrs. Zhang's shares. We say in relation to that, such a small shareholding does not provide any role within a company, nor any control over that company. It does not provide a functional link of any nature. To focus on the value of those shares, we say, is misguided. It's been put at, I think, £5 million today. It was put at $7.2 million in writing and below. We say it's wrong to focus on the value because it is not the value that provides the role within a company, control over a company, or link to a company. For example, the current market value of Apple is $2.3 trillion. So a $7.2 million shareholding in Apple would equate to a tiny fraction of a percent, 0.0025% by my maths. That, we say, would obviously not establish a link of a functional nature. But to take a different example, a $7.2 million shareholding in a $10 million company amounts to a shareholding of 72%. And we accept that would provide a functional link to a shareholding of that size. We say it is the percentage size of the shareholding, not its value, that is relevant. We say the judge was right in that respect. We say, as a check and balance, we can consider the facts of this case and how one would instinctively react if the numbers were not so large, because the numbers are not the driving factor. If Chongsing hadn't been worth $1.8 billion, but a fraction of that, say $18,000, Mrs. Zhang's shareholding of 0.4% would be worth just $72. The only difference between that example and this example is the magnitude of the sums involved, and essentially the wealth of Mrs. Zhang. And as we've seen in other contexts, wealthy consumers are still consumers. The numbers, the size of the company, the wealth of Mrs. Zhang is not relevant. Finally, on this second submission, even if one takes Mr. Zhang's shareholding into account, that does not change the conclusion in relation to Mrs. Zhang. That larger shareholding of just over 18% still did not provide Mrs. Zhang with a functional link to Chongqing. It did not provide her with any role in Chongqing, any control over Chongqing. It was not such, going back to my first point, that it would be appropriate to treat Mrs. Zhang as effectively acting for the purposes of her business, which was the first test. Moving then to our third submission, Mrs. Zhang's financial interest does not indicate that she was not a consumer. Eternity Sky have placed weight on Mrs. Zhang's interest in the transaction, but this does not indicate that she had a business motive. Consumers will regularly enter into transactions which they hope will benefit their financial interests. For example, purchasing a more economic car in the hope of outweighing rising fuel prices, or investing a nest egg in a high street bank's bond. Those are done with an intention to derive a financial interest, to derive a profit. That doesn't make the consumer any less a consumer. And it's the same here. The fact that Mrs. Zhang intended to assist her husband's business by providing the personal guarantee and could ultimately have indirectly benefited because of her 0.4% shareholding is not determinative of the question of her consumer status. The question comes back to purpose and motive. Why did she enter into the transaction? Moving then to the fourth submission. The judge did not improperly focus on Mrs. Zhang's subjective motivation. In respect of this submission, we make 5 points. The first point is that as a matter of ordinary language, the purpose for which an individual enters a contract inevitably involves a consideration of their intention and motivation. Second, whilst we agree that the test of consumer is objective, such that individual characteristics are not relevant, my learned friend took you to Costilla on that. The fact that the individual there was a lawyer is not a relevant consideration. That does not preclude the court considering evidence of intention or motivation to determine the purpose for which an individual is acting. There is nothing in the wording of Section 2.3 of the Consumer Rights Act or the directive which suggests the court should not consider all the available evidence. Further, the Court of Justice has been clear that in making that determination as to whether or not an individual is a consumer, a national court should take account of all of the evidence. We saw that in Costilla, which for the reference is Authorities Bundle 38, page 967, electronic page 944, in particular. Paragraph 22. Conscious of the time, I've got about 5 more minutes on this point, but I can pause here.
Yes, all right. Well, we'll pause here and resume at 2 o'clock. How much longer overall do you think?
In total, I'm going to be about another 10 minutes. Mr. Kirk, I don't know.
I would have thought that I would take about 20-25 minutes to respond to my learned friend. I don't have any specific responses other than one minor point in relation to the Attorney General's, the Spanish case. A small point in relation to that. I wasn't intending to do any long reply in relation to the points unless the court...
All right, well, we're well on course.
Yeah, I would think so.
All right, we've got Mr. Riley Smith as well.
Just like my 15 minutes.